Okay, and then I want to just focus on briefly this idea of related goods, because in order for something to be an infringement just means likelihood of confusion amongst the members of the consuming public, okay? There are thousands of volumes of cases over the last several hundred years over what the meaning of likelihood of confusion is. It takes on different meaning in certain industries. It can mean things like, are the categories of purchasers the same? Are the purchasers discerning and smart and sophisticated? Is it only what channels of trade? In other words, are the two products ever likely to cross paths in the marketplace? Those are all factors that go into determining whether or not there is any likelihood of confusion. But I want to finish up on this related goods thing, because I think it's important to know, because it cuts two ways. It's a way that you might also think of expanding your brand at some point. For example, this HB with the crown, one was for beer and one's for wine. Okay, so that was held that it was confusingly similar. And one that's more recent, which I think is very interesting, is all of you have heard of the Joel Gott, right? That's a second label, isn't it, for the Gott, G-O-T-T? He just successfully stopped somebody in Florida who had a water called Gott Light. So that says to me, if the winery wants to slap some labels on a bottle of water and create rights in water with their wine label, they could do that. There's another good reason not to put the word vineyards in your registration, because if you have Gott and you have the word vineyard on it, that's not going to look so good when you put it on a water bottle, right? But if you want to take the word Gott and just put it onto water, then you've got a trademark for wine and for water. Okay, so that's just an idea of how you can kind of expand the use of the mark. There's one other related goods example here, which I happen to really like, because this one surprised me, that the Sobe green tea people, have you guys seen those bottles, all over? They sued to stop a sparkling wine called Sobe, and I hadn't thought about it. Sobe is actually short for South Beach in Miami. So, and they won, even though it was the fruit drinks versus wine. So the point of bottom line is, it doesn't necessarily have to be somebody who's selling wine for you to stop them or for them to stop you, okay? Again, that's going to be case by case. It depends on how distinctive your trademark is. Sobe is pretty distinctive.